Good evening, everybody. Once again, I'm Matt Hank. It's my pleasure to serve as the chapter president for the Philadelphia chapter of the Federalist Society and to welcome tonight our distinguished guests and our moderator. I'll begin briefly by informing those of you who don't know and reminding those of you who do. The principles that animate the Federalist Society, they are three. We believe that the state exists to reserve freedom. We believe that separation of powers is critical to that goal, and we believe that it is emphatically the province of the judiciary to say what the law is, not what it should be. For those of you who are members, welcome back. It's good to see you at our first post-pandemic event. For those of you who are not our members, welcome. We like to have guests, and if any of you are interested in joining the society, please feel free to email me or check us out on fedsoc.org. With that, David, I'll turn it over to you.
Greetings and welcome to tonight's virtual debate on the recently revised Title IX regulations. You just heard from Matthew Hank, president of the Philadelphia local chapter of the Federalist Society. I want to take a moment to thank both Matthew and the Federalist Society for putting on this important debate. We have two prestigious experts in the field of Title IX as our debaters today. They will address whether the recently revised Department of Education Title IX regulations were necessary, and if so, whether the revised regulations will result in fairer Title IX disciplinary proceedings. Ms. Samantha Harris will argue that the revised regulations were necessary and that they will help ensure that both the accused and accuser are treated fairly during Title IX proceedings. Mr. Brett Socolow will argue that the revised Title IX regulations overprotect due process at the expense of victims' rights, and undermine the equitable purposes of Title IX itself. Ms. Harris is currently a senior fellow at the Foundation for Individual Rights in Education and also serves as counsel in Mudrick and Zucker PC's National Campus Discipline and Title IX practice. Ms. Harris is a graduate of Princeton University and the University of Pennsylvania Law School. For more than 13 years, Ms. Harris has advised students, faculty, administrators, and attorneys on issues of free speech and due process on campus. She lectures regularly about students' rights at campuses and conferences around the country, including recently at the judicial conferences of the Third and Fourth Circuits. Ms. Harris has been published in Inside Higher Ed, the New York Daily News, Reason, the Washington Post, Vox, and other publications, and has appeared on CNN, ESPN, Fox News, NPR, and more. Mr. Brett Socolow is the chair of TNG, a national multidisciplinary risk management consulting and law firm with more than 3,000 education sector clients, 35 executive and support employees, and a roster of 25 attorneys and consultants who are at the forefront of the field in their areas of expertise. Mr. Socolow also serves as the president of the Association of Title IX Administrators, the leading industry association for Title IX compliance, with over 3,600 active school and college members. Mr. Socolow has been interviewed on CNN and has been featured in Newsweek, Time Magazine, The Wall Street Journal, ABC News, The Chronicle of Higher Education, USA Today, The Boston Globe, and many other media outlets. Mr. Socolow is a graduate of the College of William & Mary and the Villanova School of Law. I have the honor of moderating tonight's debate. My name is David Struy. I am currently a litigator at Schneider, Harrison, Siegel & Lewis in Philadelphia. Previously, I served as a captain in the United States Army and in the JAG Corps, where I served as a special victim prosecutor, among other roles. As an Army special victim prosecutor, I was responsible for prosecuting rape and sexual assault allegations in the Army. Many of the issues that confronted me as a special victim prosecutor now confront colleges and universities as they attempt to address rape and sexual assault allegations on campuses. I frequently write on due process considerations in both military justice and Title IX proceedings. As a preface, the opinions expressed by the debaters and moderator here today are those of the individuals themselves and should not be attributed to their respective employers. I know I've spoken long enough and you want to hear from the experts, but just to give a brief history of the issues that have led to the new Title IX regulations, I note the following. In 2011, the Obama administration issued the 2011 Dear Colleague Letter, which provided guidance to universities for handling Title IX issues. In announcing the letter, then Vice President Joe Biden stated, quote, "Today we are strengthening our response to sexual assault in schools and on college campuses. Students across the country deserve the safest possible environment in which to learn. That's why we're taking new steps to help our nation's schools, universities, and colleges end the cycle of sexual violence on campus," unquote. As universities sought to implement the 2011 guidance, a rash of litigation ensued, as many argued that the 2011 guidance was fundamentally flawed and unfair as it denied due process to students accused of sexual assault. Indeed, at least 3 federal appellate courts have ruled that university disciplinary procedures were unfair to accused students since 2011. As this litigation was ongoing, President Trump was elected to office in 2016, and his Secretary of Education, Betsy DeVos, sought to revise the Title IX regulations to ensure, among other things, that accused students were afforded a fair disciplinary hearing and had the opportunity to defend themselves against accusations. These reform efforts culminated with the Department of Education releasing new Title IX regulations earlier this year. These new regulations, in turn, have resulted in additional litigation, as the ACLU and certain attorneys general have filed suits seeking to block the implementation of at least certain aspects of the new regulations. Now that the table is set, let the debate begin. At the outset, I will be affording both Ms. Harris and Mr. Sokolow 10 minutes each to explain their respective positions. And as a reminder, Ms. Harris will be arguing that the revised regulations were needed and that they will help ensure that disciplinary processes and procedures will be fair to both the accused and accuser. With that, Ms. Harris, you have 10 minutes.
Thank you. Hi, David, is my sound okay? Okay, good. All right, let me get this out of the way at the beginning. In my ideal world, would the federal government be regulating the minutia of campus disciplinary proceedings? Of course not. But the government does have an obligation to ensure that students' fundamental rights are not compromised in the course of implementing its mandates. And the judicial and regulatory developments of the past 25 years have created an environment in which schools have been handling Title IX complaints in ways that are so manifestly unfair that I believe these new regulations are necessary to effectuate this obligation. What do I mean when I say judicial and regulatory developments? Well, let's take a quick look back at the history of Title IX. David talked a little bit about this, but I'll get into a little more detail. The text itself is just a few lines long, prohibiting sex discrimination under any education program or activity receiving federal financial assistance. The original implementing regulations in 1975 focused on things like discrimination in admissions, recruitment, housing, and athletics. Today, by contrast, schools must have student behavior under a constant microscope in order to comply with Title IX. In addition to quid pro quo harassment by faculty, student-on-student harassment and assault have been found to be forms of sex discrimination that, absent an appropriate response from a school, violate Title IX. Schools are required to have equitable grievance procedures for resolving those complaints. In guidance issued in 2001, the Department of Education made clear that equitable procedures should include adequate, reliable, and impartial investigation of complaints, including the opportunity to present witnesses and other evidence. In other words, schools must have some kind of judicial process for resolving Title IX claims. In 2011, the Department of Education went into yet greater detail about schools' grievance procedures. It required schools to use a preponderance of the evidence standard in those procedures, finding it the only standard that would satisfy the equitable requirement. It strongly discouraged schools from allowing parties to cross-examine one another. It required that if schools have an appeal procedure, both parties must be equally able to appeal. And it began to dramatically ramp up the number of schools being investigated for failing to comply with Title IX. Given a broad mandate to adjudicate what are commonly understood to be criminal offenses, but without sufficient guidance as to how to do so in a truly fair way, the wheels began to come off on campus. Many schools dispensed with hearings altogether and adopted an investigative model where one person served as investigator, prosecutor, judge, and jury. Other schools had hearing panels, but trained them using prejudicial materials that relied on improper stereotypes and questionable science. Some schools provided students with adequate notice of the allegations against them. At other schools, students would find themselves called into meetings and suddenly asked to answer questions about the details of events that sometimes happened years prior, without any information about what they were alleged to have done. This was rough justice, and the consequences were immediate and severe. And all the while, of course, other schools were still sweeping allegations by complainants under the rug. The courts were beset by complaints from students, both complainants and respondents, that schools were mishandling these investigations and adjudications. Now, I'm coming from the perspective of someone who primarily represents the accused, but the horror stories from both directions were hard to believe. 18-year-olds defending themselves alone against rape allegations without the opportunity to see the evidence against them or to question their accuser. Students being denied the opportunity to present exculpatory evidence, or schools blatantly ignoring or even suppressing exculpatory evidence. Some will say these are just isolated anecdotes, but after 10 years, it's almost impossible to look at the evidence and say there's not a serious and systemic problem. And indeed, since 2011, more than 600 lawsuits have been filed by respondents alone. Others will say that the focus on procedural protections is misplaced because these are not criminal proceedings, and colleges should not be required to operate parallel judicial systems. Brett's smiling. I'm assuming that means Brett's going to say that. Well, first of all, they already are operating parallel judicial systems. That ship sailed more than 20 years ago. And the only question now is whether or not those systems are even remotely fair. But to the argument that these are just campus conduct matters, or that these are educational proceedings, it's impossible to look at the wreckage of these students' lives and say that. It's exceedingly difficult, as it should be, to get into another school, to go to graduate school, or to find a job if you have been found responsible for sexual assault, even just on campus. It may be correct that sexual assault is a form of sex discrimination. We're not here to debate that today, although that would make an interesting discussion too. But to say, hey, look, these are just civil proceedings about discrimination really misses the unique gravity of a finding of responsibility for sexual assault. Given the seriousness of the claims being adjudicated under the rubric of Title IX, there's an unavoidably quasi-criminal air to many of these proceedings, and the way they are conducted must account for that reality. So this is the backdrop against which the Department of Education decided that it had to restore basic fairness to campus sexual misconduct adjudications. When we talk about whether these regulations are necessary, we have to look at the world as it is, and in that context, the answer is absolutely yes. First of all, in response to the hundreds of lawsuits from respondents who allege they were denied a fair process, there has emerged a patchwork of case law surrounding Title IX, such that one's rights in a Title IX proceeding depend on where one lives and attends school. Given that this is a federal civil rights statute, that's an untenable state of affairs. In New York, for example, a court recently held that a Title IX investigator's failure to thoroughly investigate inconsistencies in a complainant's story may have violated Title IX's requirement of an equitable proceeding. Other courts, however, have looked at similar facts and found no Title IX violation. It fell to the Department of Education, therefore, to standardize the rights of students under this federal statute. The department also has an obligation to ensure that students' constitutional rights are not being violated in the implementation of Title IX, and that has been a rampant problem over the past 10 years. The procedural safeguards in the new regulations, a live hearing, cross-examination, meaningful notice and access to evidence, the presumption of innocence, these are all things that various courts have held are part of students' due process rights. It's a common misconception that due process rights apply only in the criminal setting. While due process rights are greater in that setting, students enrolled at public universities do have procedural due process rights that those universities must uphold. Unlike previous guidance that was issued with no stakeholder input, the department painstakingly took into account an unprecedented amount of feedback from the public during the notice and comment period. The overwhelming majority of the changes made from the proposed rule to the final rule reflect changes that were made in response to the rule's critics. Some have complained about the length of the commentary, but to me it reflects just how seriously the department took its mandate to ensure that claims of Title IX sex discrimination are adjudicated in a way that ensures an equitable process for all parties. Thank you.
Shall I take it away, David?
It's all yours, Brett.
Thank you very kindly. Samantha, I just want to thank you for thinking of me as a panelist for this debate, and I want to thank the Federalist Society for providing a forum for us to have this important dialogue. I think that's about 15 words I never thought would flow from my lips, but I thank the Federalist Society. I have a number of friends who are Republicans and a number of friends who are liberals, and we talk a lot about these regulations, and uniformly, my Republican friends are very in favor of this regulation, and my liberal friends are very against it. So it figures it takes something like sex offenses to turn Republicans pro-regulation, but whatever it takes, it has been a fascinating turn of events to see the way that this topic tends to split itself amongst the politics of those who are weighing in on it. This is a bit of an unfair panel in the sense that I don't think anybody on this panel is anti-due process. And the form and substance of the regulations that have been enacted by the Department of Education under Title IX largely cover the topic of what OCR sees as due process within Title IX. So you're not going to hear from me a perspective that I think that the due process is something that ought to fall by the wayside or isn't a source of significantly and important protective rights. I'm very much in the due process camp. I just happen to be one of those people who loves to ask the question, how much process is really due? And how do we get to a balance between the rights of all of the parties who are involved in these life-changing and incredibly complex types of complaints? The rights of complainants, the rights of respondents, the rights of institutions that become the arbiter of the sexual congress of their students and employees. And so I think everyone winds up in a difficult position. But I simply take the position that I think that OCR and the Department of Education in issuing these regulations have gone farther than I think was necessary to protect the rights of the parties who are involved. And when I say parties, I really mean that, right? I think we need to have a recognition that procedural due process protections, by and large, protect respondents, those who are accused, but the complainants within a college environment have a substantive due process right to be free from sexual or other sexualized or gender-based violence. And so I think it's important to realize that due process protections do apply to all of our parties. And I want to acknowledge that Sam and I are largely in agreement that there's a problem in the field. Right? The problem goes back perhaps 20 years, but really stems to 2011 by and large, where the Department of Education, through that Dear Colleague letter that Sam mentioned, charged colleges and universities with a very precise responsibility to address and respond to sexual violence, in addition to responsibilities to respond to sexual harassment. And in doing so, touched off a huge increase in the number of incidents reported across college campuses that has sustained almost to this day. Of course, COVID-19 has quieted things, but I think only temporarily at this point. And with this incredible increase in the case volume that colleges and universities began to process, the error rate began to go up dramatically. And at first, I think that was due in large part to the fact that when the Department of Education said to schools, you've got to build this apparatus for resolving these complaints, it wasn't like there were a bunch of civil rights investigators and hearing officers and Title IX coordinators sitting in the wings saying, oh, we were just waiting for you to say go. We had to build that capacity within higher education. And I am frequently caught saying that change in higher ed is like turning a cruise ship. You have to plan well ahead. You have to expect it to happen quite slowly, and you may not wind up in exactly the direction that you intended by the time you get there because the tides are shifting around you. But the important thing to realize is that colleges and universities by perhaps 2015 or so had really figured out how to build the bureaucracy. And then I think the problem really became one of how much training they had, whether biases were in place, whether conflicts of interest were beginning to influence the outcome of the determinations that schools were making. So what I'm saying in short is that I agree with Sam that the error rate is high. and it has been for 10 years now in terms of the way that these proceedings are carried out, and that we all should have the goal of trying to reduce and mitigate that error rate as much as we possibly can. I don't particularly point fingers in terms of that error rate. I can give you a lot of ideas about why I think it happens, but I think that there's a consensus here that it doesn't, and it needs to be fixed. But I think that one of the premises that underlies the regulations and Sam's support of those regulations seems to be that we ought to take a system that isn't working right and complicate it to the point of nausea and bureaucratize it to the point of probably what I anticipate will be systemic failure for most schools in trying to comply with the requirements that the Department of Education has set out, and that somehow making something complex to the point of turning a campus resolution into a quasi-criminal process, turning a campus hearing into a mini courtroom, is a solution to the problem when it was already impossible for the bureaucracies that were operating to handle these cases by and large at the level of proficiency that the critics of colleges and universities seem to demand. So maybe right problem, but definitely not the right fix. And I worry for the unintended consequences that always attend federal intervention in anything. And so here we have 2,083 pages of regulations and comments from the Department of Education guiding schools on how to comply with a statute that is 37 words long. Right? Let me just say that again. The Title IX statute is 37 words. The commentary on the new regulations is 2,083 pages. And most of the people in the field haven't been able to absorb all of it. And the Department of Education issued these rules in the midst of a global pandemic where colleges and universities were not fully functioning, and gave them roughly 90 days in which to become fully compliant. So we're looking down the barrel of an August the 14th, 2020 deadline to build entire bureaucracies. And no one has really acknowledged the fact that most colleges and universities, again, we're not sitting there with all of the resources sitting in the wings to do this. Title IX is, of all things, an unfunded mandate as far as these new regulations are concerned. Schools receive federal funding, but not specifically for Title IX programs. And the more the Department of Education piles on, they don't allocate more money to the colleges and universities to comply. So now we have to add advisors, right? Every party gets an advisor, and if they don't have one, the advisors have to be provided by the schools. So that means we have to build a trained coterie of advisors. We're now required to have decision makers who will chair these hearings, and schools really weren't required outside of some federal court decisions in a few of the federal circuits to have a live formal hearing. So we'll have to go out and hire or deputize those individuals within the organization already. We're going to have appeals officers. I agree with that, but it's part of the burden. Most schools had appeals processes before the regs. They'll have appeals processes after the regs, but we'll have to train those individuals. And one of the other implications of the regulations is that we'll have to train more than one, because there is an appeal that is allowed of the hearing, the outcome of the allegations, but there's also an appeal that's allowed of the dismissal of the allegations early on. Those appeals can't be handled by the same individual. That'd be a conflict of interest. So you're going to have at least 2 appeals officers. You're going to need someone to facilitate this hearing in addition to the hearing chair. And so we're building bureaucracies of investigators, bureaucracies of Title IX coordinators, deputies, and we're doing all of this by remote, where colleges are not in session. They're unsure whether they will be in session anytime in the fall. And we have to bring stakeholders together to make important internal decisions within the university about how policy and procedure will be formed. So it's certainly a pressure cooker. And one of the important points that I wanted to make, in addition to the fact that I think that the regulations are not necessarily going to solve the error rate problem, is that I think this is Congress's problem to solve. You know, I was interested to hear when Matt introduced the principles of the Federalist Society, that one of them was the lack of intervention by the federal courts in the province of other departments of government. And so if you ask in an ideal frame, where should due process rights within Title IX have come from? They should have come from Congress. There's nothing within the statute itself that authorizes the Department of Education to have issued these particular regulations. And so I think that as we look at the challenges that were mentioned in the opening to the regulations, there are 4 federal lawsuits filed against them to date, and I'm sure more will come. A lot of what's going to be argued is that OCR overstepped, that the Department of Education took this opportunity to read into the statute of Title IX a due process clause. And like I've said to many of our members at ATICSA over the last couple of weeks since the regs arrived, where's the due process clause in the Title IX statute? Can someone point it to me? I want to ask Sam a question. She doesn't have to answer it now. I'm going to use all of my time, but I want her to respond to this after we do. And it has to do with the due process clause and whether she's ever found it within the Title IX statute. But more pointedly, what I want to ask is this. Do you agree with this premise? I have a premise that says that the statute itself requires no recipient, right, no college, university, or school, federal funding recipient, to discipline any individual for anything. You can comply with Title IX without having to discipline anyone. And if that is true, and you don't have to agree with it, but I want to know if you do at some point, if that is true, how could due process rights be inherent within the Title IX statute? Because, of course, to regulate on the statute, any federal agency has to be rationally connected to what the statute is set to protect. And one of the things I want to frame for all of our participants and listeners to the debate today is that when OCR is saying in the new regulations that due process rights are required, they're not saying capital D, capital P due process rights. They're not saying these are due process rights that are derivative of the Fifth Amendment or the 14th Amendment of the U.S. Constitution. No, they're saying these are rights that are inherent, lowercase d, lowercase p, within the Title IX statute itself. Well, how can that be possible, Sam, if the statute doesn't require discipline at all? Due process must be inherent within a disciplinary process. There has to be a property right at stake. I don't see property rights at stake in this statute, and if you do, I'd like to know where you find them. So let's talk about the topic of what rights are included within the regulations. I would posit that the rights that are codified now within these regulations that will take effect in mid-August as due process protections go further than the sum total of all due process protections that have been applied to respondents on college campuses by every federal court in this country. If everybody thinks all OCR did here was reflect where the courts were already heading, please understand that these regulations require immediate notification to a respondent once a formal complaint has been made on a college campus. That's a right that criminal suspects don't have. These regulations require the full suppression of a respondent's statements at a hearing if the respondent refuses to testify. Not just their statements at the hearing, but any statements they've made to any witness, any statements they've made to investigators prior to the hearing. That's a right that Baxter versus Parmigiano doesn't give to defendants in civil proceedings. So one of the reasons why my argument is premised on the overreach by the Department of Education is because they're giving rights that the courts haven't even seen fit to give. And so when you talk about whose turf is this, I think the turf was Congress's to enact new law and protect due process rights if they felt it was necessary to do so. And I think the court should be enforcing, not making those rules. The last point I'll make, and then I'll turn things over to my erstwhile colleague, is that when I say that I don't think this is the right fix, I'm speaking from the perspective of having done this work in a college environment for 22 years and wanting the right fix. I've been involved in 1,000 different campus sexual misconduct cases as an investigator, as legal counsel, as chair, whatever role you can possibly imagine. I've probably sat in the seat. And when I look at this, I see that OCR has brought procedural fixes to a substantive problem. All the regs do is give more procedural protection to respondents. But the problem is substantive, meaning that we have people who are not making high quality decisions. How do we increase the quality of decisions and reduce the error rate in these cases? It's got to come from training. which is something Atixa certainly has a corner on in the market, but it also has to come from a careful vetting process that puts people in place who don't bring biased perceptions to the decision-making process. And so if OCR really wanted to solve this problem, they would have codified training requirements. Yeah, they put a few things in the regs, but they didn't talk about how much training is needed, by whom, for how long, at what level of competency. And they didn't put a lot of information in the regs about how we should be vetting those we seat as chairs, as investigators, as decision makers in the process to ensure that they are as free of bias, or as I like to say, multi-partial. No one is free of bias, but as multi-partial as they can be, and as capable of making objective decisions as we all want them to be. Thank you for this time. I now look forward to dueling swords.
Thank you, Brett and Samantha, for your initial statements. Prior to turning it back over to the debate participants, as you can tell, both very knowledgeable in this topic, and that will leave me as the moderator without much of a job tonight. But I will definitely defer to the back and forth between the two of them. But for the audience today, I do want to note that there is a Q&A feature in the bottom of your screen, I believe. Feel free throughout the course of the debate to ask questions. This is a debate with no definite end time, so we will go, and the participants will parry, and then we will try to address some of those questions. And with that, Samantha, obviously Brett gave you a lot of material to respond to. In addition to that, and he touched on it briefly, if you could respond to his specific questions to you, but also address some of the federal appellate court decisions and their rulings and the effect, I guess, of those rulings in the absence of new regulations, i.e. what would be the alternative if the new regulations did not come out? Thank you. And I'll say 10 minutes again, but we'll try to keep it with 10-minute answers. Thank you.
Yeah, and I don't think my answer here is going to go 10 minutes. I think that Brett and I can sort of get into the back and forth. So, the question that Brett asked me, as I understood it, was first sort of, does Title IX actually require schools to discipline students for sexual misconduct? And if it doesn't, then what authority does the Department of Education have to require the kind of due process protections that these new regulations require? So, it sort of goes back to what I said at the beginning. In my ideal world, would federal government be regulating this minutia? If we were to break the whole system down and build it up from scratch again, is this what I would do? That's a very different question from, is this what needs to happen now? Because as you say, Title IX itself is very brief, and it has taken, since 1972, I'm trying to do math in my head and failing, but however many years that is, it has taken this long to get to the point where we are now. Title IX itself is very brief, and even the early judicial decisions that started to find that harassment, because initially harassment wasn't really contemplated within the realm of sex discrimination, right? It was really contemplating discrimination in things like admissions and recruitment. And then in 1977, you had this decision out of the District of Connecticut, Alexander v. Yale, where a court found for the first time that a school, Yale in particular, could be held responsible for failing to respond to allegations of quid pro quo harassment by a professor. Now, what was interesting about the Alexander case is that there were a number of plaintiffs in that case. Two of the plaintiffs were students who actually alleged that a particular professor had explicitly not given them a good grade because they refused to submit to his sexual advances. And the court allowed those plaintiffs' claims to proceed. But there were several other plaintiffs whose claims were dismissed, and these were plaintiffs who had sort of argued that by having to kind of witness this professor's behavior and just, be a party to his demeanor, that they also had harassment claims. And what the District of Connecticut said in response to those plaintiffs and in dismissing their claims, I think is just sort of illustrative of how much the interpretation of Title IX has changed over the years. So what the court said was, in dismissing the claims of these other plaintiffs, no judicial enforcement of Title IX could properly extend to such imponderables as atmosphere or vicariously experienced wrong, and the claims just mentioned are untenable on their face. Now, obviously, we've come to a place where claims about a hostile environment, claims of sort of third-party witnessing harassment committed against another person. Those are all things that now do fall under the auspices of Title IX. And that's really why I said that, we've gotten to a place through, years and years of judicial and administrative decisions where schools really do have to have student behavior under a microscope. And, in the 2001 guidance, the Department of Education said that schools had to have adequate, reliable, and impartial grievance procedures that included the opportunity to present witnesses and other evidence. So whether or not I think that Title IX mandates, that the language of the statute passed in 1972 mandates that schools discipline students for harassment, which I think I would concede it doesn't. I think that, we would have to break everything down and go back to 1975 and rebuild, which again, my sort of premise in this debate is we have to take the world as we find it. If we want to have a debate about whether to really break it down back to 1975, and start from scratch, I feel like that would be a very different conversation, but that's not happening. I mean, if we didn't have these regulations, the 2001 guidance, which does require judicial procedures for resolving Title IX claims, would still be enforced. And I think that, my belief that these due process protections are necessary stems from my belief that the government has an obligation to ensure that constitutional rights are not being violated in the implementation of these laws. And that's exactly what we have seen happening over the past few years, well, more than few years, I mean, particularly the past 10 years. So I think that would be my response to that question. And I guess my question for you, Brett, is just why now? I mean, have you had this concern about sort of the growing bureaucratization of the process, that we saw in 2011 and 2014 when, very detailed guidance was issued? I mean, I realize that this is 2,000 pages long, but the reason this is 2,000 pages long is that 120,000 people, most of them, opposing these regulations, submitted comments that the department, I think, very thoughtfully and painstakingly responded to. I mean, in terms of the actual substantive requirements, the 2011 Dear Colleague letter and the accompanying 2014 Q&A also contain a lot of detail about how colleges need to do this. And that detail led to, I really think, a systemic violation of students' rights. So that's kind of what I would throw back at you. And I hope that I answered your question.
Yeah, I mean, I think it was a fair riposte, and I appreciate it. The point I was driving at was that if we have some agreement that there isn't a due process clause within the Title IX statute, one of the things the Department of Education will need to do is defend the regulations under the Administrative Procedures Act. And for our judicial audience and for our attorney audience, many of whom are involved in this type of litigation, I think one of the vulnerabilities of the regulations is that, of course, the regs must be rationally related to the statute. And if we accept my premise that the statute doesn't require anyone to discipline anything for anything, right? We can restore someone's access to an education through remedial aims, or what the Department of Education now calls supportive measures. Yes, we do impose discipline, but we're not required to. We could transfer someone to a campus in Siberia. We don't have to fire them, right? There are lots of different ways to handle these cases that, in doing so, we're not invoking due process rights. All I'm saying is that if that represents agency overreach within a typical conservative mindset, it would be consistent for us to acknowledge that and acknowledge the premise that I'm making, which is none of us, TICSA would not, I would not object to Congress enacting the very same protections that they placed into the regulations through the appropriate, house of government in terms of the responsibility for doing so. I don't think it ought to be OCR's job to have to protect these rights, and I don't think it was OCR's job to do so back in 2011. So I'm consistent on that. I actually saw in the Q&A that was posted from one of our participants, Michael Allen, a question as to whether a TICSA was opposed to the guidance that was issued in 2011 or the Q&A that came out in 2014. And no, we did did not take positions in opposition to those documents, but we certainly were critical of them, and publicly so, to the extent that they caused confusion or that they represented overreach or that they were areas in which we felt that colleges and universities ought to be left to their discretion to determine appropriate practices and not be dictated to by the Department of Education. My gosh, I sound like one of you now. And so, yeah, I'm fully capable of being critical of all agency overreach, regardless of which administration it happens to issue from.
Thank you both for that. And I guess we touched briefly on the appellate court decisions finding the procedures unfair as they pertain to those particular cases. I guess moving forward, as the ACLU and these attorneys general have filed suit, Samantha, could you provide your understanding of those two lawsuits and perhaps opine on the strengths and weaknesses of those pending lawsuits? And then I will turn it over to Brett for his opinion on both of those.
Yeah, I mean, those lawsuits are very detailed, and I think there are they have varying strengths. As far as I know, there's the ACLU suit, and there's the suit by the National Attorneys General, and then there's the suit by the state attorneys general, and then there's the suit by the National Women's Law Center. It's interesting. A lot of the complaints, a lot of the claims in the lawsuit relate to the differences between the way that Title IX now has to be enforced as opposed to Title VI, which governs, racial discrimination and harassment in schools. And I think that this is actually a very, very interesting conversation because, it really highlights for me, in 2011, when the Dear Colleague letter was issued, the Department of Education dramatically changed, the rules for how sexual harassment complaints needed to be adjudicated, preponderance of the evidence, dual right of appeal, and didn't make any changes to the way that, any corresponding changes to the way that Title VI was enforced. So you had situations where schools that had been using a clear and convincing standard to adjudicate everything under their conduct code suddenly had to use a preponderance of the evidence standard to adjudicate claims of sexual harassment and sexual harassment only. And so, there's this sudden concern about this disparity that really has not been raised, despite the fact that the disparity existed in the other direction for years and years. So I think that's a claim in the lawsuit that, to me is pretty disingenuous and is brought up pretty systemically throughout the lawsuit. Similarly, they say new types of procedures are required in sexual misconduct cases only. Again, I think where were these concerns in 2011? But I think that also reflects the fact, and, the department in these regulations makes the point that a lot of the procedures it has prescribed because of sort of the unique position of colleges in adjudicating these sexual harassment and misconduct claims. Because, typically, when colleges are adjudicating claims of things like racial discrimination or harassment, they're not adjudicating, violent racial assaults that are taking place. Typically other types of crimes, while there will certainly be conduct consequences on campus if a student commits a crime, typically the investigation and adjudication of that crime is not going to be done primarily by a campus tribunal. And so I think that there are circumstances unique to the way that Title IX has evolved and that necessitate these types of procedures in this context. So, overall, I think it will be interested. I mean, the state attorneys general suit focuses a lot on how these federal regulations preempt state law. There are a lot of different claims in them, and it will remain to be seen exactly what happens. FIRE filed a motion to intervene today on First Amendment grounds to protect the Davis standard, which is, I'm sure, something that Brett and I will be discussing at some point in this debate. But I don't know. There's so much ground to cover in these lawsuits. Did you have a sort of more specific question about them?
I think just for the audience, given that the new regulations have been promulgated and that universities, and this will be a subsequent question for Brett, whether universities are taking steps to implement them or if their strategy is perhaps not to do so. But I think just an orientation to those at least 3 competing lawsuits, and as you are an expert in this field, whether or not you thought they'd be successful. But on that note, I'll give you a chance.
I have one more point to make actually about them, which I think is something Brett and I can talk about a little more too, because it was something, the short implementation period was something that he brought up during his opening remarks. And, to me, that is really sort of a hot button issue because the reason the regulations took as long to come out as they did, first of all, schools have been on notice that these were coming for many, many years. The 2017, September 2017 was when the Dear Colleague letter was rescinded, and the Department of Education telegraphed in its 2017 Q&A a number of the things that it thought would be important. And then, of course, in November 2018, it issued the Notice of Proposed Rulemaking, which really put schools on notice that these types of changes, particularly with regard to the hearing procedures, were coming. And what I saw in the time period between November 2018 and May 2020, when the regs came out, was a lot of really bad faith obstruction on the part of opponents of the regulations. For example, after the notice and comment period closed and after the Department of Education concluded its review of the comments, it kicked the regulations back to the Office of Management and Budget for a final review. And groups started filing requests for meetings with the Office of Management and Budget, just further and further and further out in what, appeared to us to be a delaying tactic. And then it turned out later in a video that emerged that it was a deliberate delaying tactic. So I really struggle with this argument that, there's not time to comply with them, when the reason they took so long to come out in the first place was in part because of these obstructive tactics, and when schools have been on notice about them since November 2018. So to the extent that all of these lawsuits sort of raise that issue about, oh, woe is me, now schools have this short time period to comply, that's one where I feel like schools really have been on notice and should have been preparing for this.
So, Sam, if I understand you correctly, you just characterized all of those meetings with OMB as bad faith, but wouldn't you?
No.
Wouldn't you agree that all of those groups had a First Amendment right to meet with the government, to have a say in how they would be governed?
Sure. I'm not saying they didn't have the right to do it. I'm saying they engaged in...
Is it bad faith or free speech? I just want a clarification here.
Can free speech not be made in bad faith? Can an argument not be made in bad faith?
Absolutely not.
An argument can't be made in bad faith? What?
Not if it's protected speech.
What?
Not if it's protected.
But I think that their purpose was not to, these were all groups that had submitted comments. I believe that their purpose was to delay the process and not actually to get further on record here.
If you think I'm going down the intent argument hole with you right now, I am absolutely not. But what I do want to respond to is the comment you made before that it hasn't been historical that somehow colleges have been engaged in addressing criminal types of behaviors. And I find this such a red herring that it is critical for us to address it. Every single institution within our society addresses criminal or quasi-criminal behavior and has from time immemorial. For example, government agencies in dealing with employee misconduct, every major corporation in dealing with the fraud of an employee, K-12 schools, colleges and universities. Hazing is both a policy violation and a criminal offense in many jurisdictions. So to argue that somehow getting into the business of addressing sexual harassment versus sexual assault is unique to the college environment ignores the fact that it's actually not unique at all, and that most organizations have parallel systems of justice set up to protect the rights of the organization and the employees within it, and in this case, students. Seeing a lull, I want to pose another question if I could. I mentioned in my opening that the rights within the new regulations are an overreach, meaning that the rights go beyond the rights that are extended to those who are accused, our respondents, in any court in the land. I gave a couple of examples of immediate notice. I gave the example of suppression of statements. I would add feedback on the report. In what criminal process does a defendant get to review the investigation report and provide critical feedback as OCR has designed in these regs, or to deal with a complex set of new rules of evidence made especially for that setting, right? We don't have federal rules of evidence in the campus process. We now have OCR invented rules of evidence. And so what I want to talk about is when I say that the how much process is due should be part of this conversation. You're familiar with Matthews versus Eldridge, right? You know that the federal courts have established this balancing test between the property rights that are at stake and the additional burden on the organization asked to be able to provide procedural protections, and also the rights of, let's say, a complainant in the process and their protections. Can we have a moment's conversation about the fact that if these regulations, and I think they will, if these regulations create a systemic chilling effect on the willingness of complainants to come forward, that the courts who have imposed due process requirements, that OCR that has now imposed due process requirements, have forgotten the balancing part of Matthews versus Eldridge and ignored the institutional obligations, which I talked about in my opening. How do we manage this bureaucracy? But also, what about the fact that even if respondents are better protected by these rules, complainants have been left completely out in the cold? How is that ethical?
Well, first of all, I don't believe that these rules leave complainants out in the cold. I mean, I think that I just fundamentally disagree with the idea that procedural fairness should dissuade people from coming forward. And I believe that, the due process protections or the procedural protections, let's distinguish them from constitutional due process protections, although, courts around the country have held, that various pieces of these regulations are the types of things that are constitutionally required, but calling them procedural protections for the moment. The procedural protections that have been built in reflect the reality of what has gone wrong in so many of these cases around the country. They reflect the fact that schools frequently suppress exculpatory evidence, that schools frequently expect students to answer allegations against them with little to no idea of what they have done wrong. And I think that is the basis for building those protections into the grievance process.
Yeah, and you're not going to get a lot of argument to me that there are systemic failings, right? This is something I've been working for 22 years to try and cure within my own field. And so, yes, there has been suppression of evidence. Yes, there is bias that rears its head in these cases, but at no more of an error rate than any other process that's used to correct these kinds of behaviors that aren't subjected to 2,083 pages of new regulations. Isn't it the case that we already have the courts there to enforce? They issue their decisions as they see fit, and if somebody's rights are violated, that's an appropriate system for addressing it.
Well, again, I think that part of the problem is that this is a federal statute and that right now we have this patchwork of decisions. So your rights in a Title IX proceeding really depend on where you are in the country. But also, I'm sorry, I completely lost my train of thought. Can you rephrase? Can you say that again?
I think you're right. We have this patchwork of decisions, right? And therefore, if the courts can't agree on what rights should be protected, doesn't that tell you something, right? If a court in California sees due process, let's set it up the way it actually is, right? If the Sixth Circuit fundamentally disagrees with the First Circuit, right, and the Third Circuit is off doing its own crazy thing now about contract law, and none of them agree with each other, then how does that show a consensus for what rights ought to be protected if you're a respondent in a campus process?
Well, see, but that's where I would disagree with you, because I think where courts really disagree is the extent to which, it's appropriate for courts to insert themselves into campus judicial proceedings. A lot of the decisions are not, well, we don't think that students should have these rights, but, well, this isn't the province of the courts to say. And if it's not the province of the courts to say, then I believe that it is the province. I mean, to the extent that the reason schools, look, one of the things we haven't really talked about yet, but that is the case, is that schools are free to have other types of conduct policies that regulate conduct that isn't regulated by the Title IX policy. But to the extent that the federal government is requiring schools, and I would argue that the 2001 guidance with the requirement of prompt and equitable procedures that include the opportunity to present evidence and to call witnesses does really mandate some sort of judicial proceeding. I would argue that to the extent that the federal government is requiring schools to have those kinds of judicial proceedings, then it's incumbent on them to, establish the procedures that are going to make that fair. And I think it's an interesting question in terms of, the other types of conduct policies that schools have. And that's something we haven't really talked about, right? I mean, Title IX is an anti-discrimination statute, right? It is not sort of a catch-all statute meant to regulate all types of behavior between the sexes. And this is where sort of one of my fundamental problems is, because I think that, one thing that colleges and universities are really trying to do is sort of fundamentally rethink what it means to consent to sex, right? They're really sort of, enforcing new norms about sex and consent, and they're doing it through the rubric of Title IX and calling it, sexual misconduct and sexual violence. And I think that, to the extent that colleges want to have other types of conduct procedures where they use a different nomenclature to talk about these sort of new expectations for students, I think that's a very different discussion. But when we're calling things sexual assault and sexual violence, I think the procedures used to adjudicate those things have to reflect the seriousness of those offenses.
You lost me there a little bit. It sounds like you want 1950s sexual mores to continue to apply on college campuses and all these new...
Not at all. Not at all. But I'm saying that it is colleges' right to do that if they want. It's colleges who seem to want to bring back sort of an odd neo-Victorianism. I'm not arguing for it, but I'm saying that if they want to do it, don't call it sexual assault. Call it something else. Because part of what is driving this need for due process in this setting is the fact that when someone is found responsible for sexual assault or sexual violence, the impact on the rest of their life, as it should be, is extremely severe. And so there's a growing sense that you cannot simply find someone responsible for that without the kinds of procedural protections that we're talking about here.
To paraphrase you back to you, you just essentially said that colleges are experimenting with this newfangled thing called consent, which has all been a part of bedrock case law on sexual violence since about the 1970s. But however fresh you think it happens to be, I just want to be very clear about something. The Department of Education in these regulations codified a definition of sexual assault that is based on consent, not on 1950s notions of force or resistance or anything along those lines. So while you may think it is new and fresh and experimental for colleges to go down this road, OCR just codified it.
Brett, you're putting words into my mouth. I'm not questioning that sex needs to be based on consent, but OCR did not take a position on affirmative consent in the regulations. And in fact, efforts to import affirmative consent standards, which are popular, increasingly popular on college campuses, into the model penal code and the ABA model code, have failed. Nobody has been willing to import these new this new understanding of consent that has grown on campus into the criminal law. So I'm in no way saying that I do not think sex should be based on consent and taking a 1950s view of things. You're putting words in my mouth here. Now,
well, let me ask you a follow-up then. If that was unfair, fine. You've now made a distinction, which I think is relatively incoherent, between consent and affirmative consent. So if I walk up to you and I ask you if I can have your wallet, and you say no, I don't take your wallet. If I walk up to you and I say, can I have your wallet, and you say nothing, I don't take your wallet. So what's the difference here between consent and affirmative consent that you think is so very outlandish?
Give me a second to collect my thoughts here, because I didn't necessarily expect this to be going in this direction. But I think, affirmative consent is more than, affirmative consent is about a lot more than simply, silence not equaling consent. I mean, you have been in these proceedings where consent is atomized into every microscopic piece of, how did you know you had consent to put your arm around the person? How did you know you had consent to do this? How did you know, and then, there are questions of whether it has to be verbal or physical. And I think that, there's just, my experience is that a lot of conduct that is defined as that is treated as sexual assault on college campuses is not conduct that could be prosecuted in any court of law and is in fact conduct that is often wholly lawful. So that is my premise. Okay, I'm not saying that if you say, can I have your wallet, and I don't say anything, that, but I'm saying to you, if you come up to me and say, can I have your wallet? And I say no, and you say, but I'd really like your wallet. And I say, I don't think I want you to have my wallet. And you're like, please, really, I could use a few dollars. Could I have your wallet? and you say, and I say, okay, here's my wallet. That's more the scenario that I'm talking about.
I think that was a good comeback and a nice recovery. Let me put it in this context. Take the Brandeis case, right? I'm sure you're familiar with it, right? You've got two guys, they're dating, and they engage in all kinds of things that dating people do. And at one point, they're in the shower together, and so one boyfriend looks at the other boyfriend and, oh my God, sees a penis. Well, once they break up and everything goes south, there are allegations filed that one boyfriend looked at the other boyfriend in the shower and saw his penis without consent, right? And Brandeis takes that forward and eventually becomes a federal lawsuit. So you and I would both agree that there are some applications to consent that can seem absurd within a college environment. So help me understand this. What within these 2,083 pages of regulations would stop a Brandeis from pursuing a case like that?
Well, first of all, I think that the ban on the single investigator model would prevent the type of abuse that allowed the Brandeis decision to come out the way that it did. I mean, I think that the requirement, of proper notice, because the student in the Brandeis case was not given proper notice and an ability to respond, the opportunity to actually have a hearing where he has the ability to present his case. I'm not saying that there are never going to be bad decisions made. One place where I think you and I both agree is on the essentiality of proper training and better vetting. I mean, procedural protections truly are only going to get you so far if you have, biased or poorly trained adjudicators, and that is something I agree with you on 100%. But I think that when you look at that Brandeis case and you look at where things went wrong, a lot of things went wrong in the absence of the kinds of backstops and procedural protections that would prevent a case that ridiculous from making it all the way through to a finding of responsibility.
For those of you watching from my office, we had an over-under on how long it would take me into this debate to use the word penis. We hit it at about an hour and 15 minutes in. Sam, we've got, I want to be mindful of the time. We haven't talked about the elephant in the room yet, right? We've danced around live hearings a little bit. Let's talk about cross-examination.
Cross-examination, I knew it was coming. All right, so.
Let's just start.
What'd you say?
Please, go ahead.
So here's what I would ask you about cross-examination. So, the article that you cite, I mean, you put out, a piece saying that there was no research indicating that cross-examination creates more accurate results than other forms of adjudication. But the article that you cited there was an article that was about the limits of cross-examination in eliciting eyewitness testimony in mistaken identification cases. And that article itself acknowledged that cross-examination is good at completing the story by eliciting facts that remain suppressed or undeveloped on direct examination. And I think that, in my experience in campus sexual misconduct cases, it's often these kind of undeveloped facts, things in a party statement that go unchallenged by an investigator that are critical to a meaningful credibility assessment. So I'll just give you one example from my own practice, which is, I recently had a case where, the complainant sort of did everything to minimize her role in an evening that she spent with my client. And one of the things that she claimed was that the only reason she had sat next to my client on a beanbag chair in the room where the incident took place was that it was the only place in the room to sit. This wasn't actually the case. It turned out that the room had several floor cushions that other students frequently used to sit. And the investigator never questioned the complainant's statement about there only being one place to sit. So if you looked at the investigative report, what you got was, well, yes, she did sit next to him in the room, but because there was this one place to sit. And so, we were able to ask questions. And so when we were able to ask questions, the complainant had to admit that, in fact, there were other places to sit in the room. And similarly, the complainant had characterized certain text messages from the client as being sort of pushy about wanting to meet up. But when we were able to show her those text messages and say, okay, could you please point us to, what was pushy in here, because they weren't, she had to admit that they weren't. And, having gone through that process with this student, I can say with virtual certainty that if we had not been able to engage in cross-examination about the inconsistencies in her story, the client would have been found responsible. So to me, that really resonates with what this article itself says, which is that cross-examination is really useful for eliciting sort of suppressed or undeveloped facts, which, not every case. Are there cases where you don't need to do it? Certainly. I just had a hearing where I did not pose any questions of the other party. But, you know, in cases where you do have those types of undeveloped facts, I think it really can be the difference between someone being able to exonerate themselves or not.
Yeah, I mean, it's artful to construe my words that way. And I want to be clear then that I didn't say that there wasn't a utility to cross-examination. I said it's not proven to be better than any other system of eliciting this information. And of course, there's no way we can cite anything to the contrary to that premise, because there's no data to show that. Nobody's studied the campus process to know what the rate of failure or inaccuracy might be. What I would say to you, though, is that the student who has a gladiator like you from Penn, right, can point out the insufficiency of an investigation. But the student who is served by an advisor, who is a campus history professor or a librarian appointed by the school, may never get to that level of precision. And so I don't know that the system that OCR has implemented here, where parties can have their own advisors, maybe they can afford somebody like you or me, maybe they can't. If not, they're going to go with an advisor appointed by the institution who may or may not know to point out these sort of things. But I've been an investigator of these cases for 22 years, Sam, and I want to assure you of something. If my party was represented by an attorney, and in the investigation, that attorney or their client thought that I had missed something, failed to obtain evidence, failed to somehow find out or inquire into something like you just pointed out, they would point that out to me in the investigation, and I'd go look for it and find it. I can tell you that because I've been doing it for 22 years.
But not every school, just like not every student.
Let me finish my thought. So why isn't it sufficient for any advisor in the process to point that out during the investigation? I'm not talking about a return to the single investigator model. I've never thought that made any damn sense. But my point is, there is nothing about a live hearing and nothing about adversarial in-person cross-examination that would stop you from pointing out the very error you just addressed to me as the investigator, even without a hearing, right?
Well, I mean, Brett, the first thing I would say is that I think, the same thing that you said about what about the student who can't afford the good lawyer. What about the school who can't afford Brett Socolow? Not every school can hire. I have no doubt that you are a good investigator, but I also have no doubt that not every school can afford you.
And I don't bet my advertising next, right?
What'd you say?
Sam Harris has no doubt that Brett Socolow is a good investigator. It's going up on the web, man.
But I think that sort of, these disparities exist, but I don't think that the fact that, you can better acquit yourself if you have a good lawyer means that no one should have that opportunity.
I think you just made such an important point for me. There is no school out there that can afford to hire somebody like me, legally trained with 22 years of experience of investigating more than 1,000 sexual misconduct complaints, because there aren't people like me. There are a handful of us, right? And so what we're asking for is a bunch of administrators who have some other kind of background and training to go try and do, after some days of diligent certification from us, to go try and do what I've learned how to do after 22 years, and then you wonder why the system doesn't work. Right? It's because the infrastructure isn't there to support the kinds of things that OCR wants us to do, and then it just piles on with incredible complexity. We spent a lot of time training over the last 2 weeks to help new administrators who are entering into this process after August to understand what it's all about. It took us half a day to figure out with all of them how to manage the pre-hearing and the 10-day period and then another 10-day period after the investigation report is done, so that everything could go to the hearing and be determined whether it was relevant or not by a decision maker. I don't honestly know more than a handful of college administrators who are going to be able to chair that kind of process the competent way that you and all the critics of the colleges somehow expect that they just inherently know how to do.
Well, but the problem is, as I said, that ship has sailed. I mean, I don't disagree with you that OCR has made it very difficult for college administrators. But OCR has been making it very difficult for college administrators since the 1990s. And I think that by adding these procedural requirements, they're going to make outcomes more equitable. As I said, I don't think, in my ideal world, would colleges have to have these parallel judicial systems? Probably not, but that ship has sailed, and I'm looking at the world as it exists now. I mean, like I said, if we want to talk about what would you and I do if we had the opportunity to go back in a time machine prior to 1997/2001, and prior to Davis, because one thing that's really interesting about the Davis decision is that even though in this context, the Davis definition of harassment is brought up as sort of this, oh my gosh, nobody's going to be able to be found responsible for harassment. It's impossible. Davis was a decision written largely by the court's liberal majority that found that there was a private right of action against schools, for failing to respond to student-on-student harassment, with a really blistering dissent by Kennedy, who, now by today's standards sort of appears to have been looking into a crystal ball and said, oh my God, this is going to unleash, an avalanche of litigation. This puts schools in a nearly impossible position, right? So if we want to have another discussion about what you and I would do if we could go back and change the Supreme Court and change, the way that these laws have been, written and enforced for the past 30 years, I think that would be a very different discussion. But assuming we can't do that, I think that these regulations, as opposed to the sort of piecemeal guidance that we've had over the past 10 years, which really, as I said, sort of, tell schools they have to really aggressively pursue these things, but don't give them enough guidance to do it, fairly. I think that these regulations are going to be an improvement. And that's why I sort of framed my argument as, in the world we live in, I think these regulations are necessary.
You said in your opening how well thought out and how carefully OCR had responded to all the comments. And so I know you're a fan of the regulations, but I'm concerned about the way the regulations handle the issue of preponderance of the evidence versus clear and convincing evidence, right? So the Department of Education decided that somehow there are only two standards of proof in the world, and that's not arbitrary and capricious, right? And that colleges should make a choice, as should K-12 schools, between applying POTE, the preponderance of the evidence, or clear and convincing evidence in their cases, and that they must impose the same standard for all faculty, student, and staff resolutions. Now, OCR didn't focus on more training. They didn't focus on getting rid of bias. They focused on making sure that there's a clarity to the standard of proof. How is that equitable? If schools move to clear and convincing evidence, Sam, won't it be the case that more men are found not responsible? How is that equitable to the women on campus?
Well, first of all, how was it equitable in 2011 when preponderance was mandated in Title IX proceedings, but not in other types of harassment proceedings?
It actually wasn't mandated, though. Of course, the 2011 Ricali letter did not have force and effect of law.
Well, for all intents and purposes, I treat it as a mandate. Schools felt obligated to comply. If they're going to take away all your money if you don't comply, to me, that's a mandate.
They couldn't have enforced on that. You agree with that, right? There was no basis to.
Every school in the country treated it as a mandate. There was not a school in the country that did not move to the preponderance of the evidence standard in 2011.
Carefully. All I'm saying is they were coerced.
I think this is semantics.
They were coerced, not required. There's a difference.
I feel like there are some questions I could ask you about that might. So coercion is not. Are you saying coercion isn't a problem, Brett?
It depends on whether you ultimately consent as a result. Go back to that point, though, right? Am I making a true statement, right, that if you implement clear and convincing evidence, which is what, a 65% to 85% certainty, something like that, versus a 50.01% certainty of preponderance, right, the 50% plus a feather idea, right? If you increase the standard of proof, which many colleges will be required to do by the cynical provision in the regs that will force that upon them, isn't that the case that you will systematically advantage men as respondents over women as complainants?
It sounds like you're making the argument that the National Women's Law Center makes, which is that the presumption of innocence is not equitable because it advantages men.
No, I have a presumption of innocence. I won't even go down that rabbit hole with you. I have no objection to a presumption of innocence. I've always applied one.
But by your argument, how is a presumption of innocence equitable? If you're presuming the man innocent, then doesn't that favor the man over the woman?
No, because to me, a presumption just means we can start at 50-50, so nobody's favored, right? There's no violation. There's no finding of no violation. You can start from a level playing field. So I have no quibble whatsoever that I don't think we needed a presumption of any kind in a non-criminal process, but OCR doesn't seem to understand the distinction. But that's not really, for me, of interest in the debate. What I'm really concerned about is that I think that this change in standards is going to have a systematic effect that is gender or sex-based. I can't see how it won't.
Well, but again, I mean, I think that the requirement not to discriminate, I think that a lot of what these regs do, they do have a lot of prescriptions for how schools need to conduct their grievance process in order for the grievance process to be fair and to respect the rights of both parties. But the non-discrimination mandate, I mean, all of the things surrounding, supportive measures and things like that, the school has an obligation to respond to sexual harassment under Title IX, even if a formal complaint is never filed. So I don't think that prescribing due process procedures, including an evidentiary standard like clear and convincing, or allowing an evidentiary standard like clear and convincing in the disciplinary process, disadvantages complainants, because regardless of whether they choose to file a formal complaint or not, the school has the obligation to take supportive measures, to take those steps to remedy the effects of the alleged discrimination. So I don't think that having a higher evidentiary standard, in the disciplinary process is inequitable under Title IX. Now, in fact, in terms of the regulations and the evidentiary standard, I actually preferred the formulation in the NPRM to the formulation in the final rule. I think that, what the NPRM seemed to me to be trying to do was to remedy a problem that FIRE had been pointing out for a long time, which is that in 2011, when the Department of Education coerced schools into adopting the preponderance standard, it created a situation where you had this standard, the preponderance standard, other types of misconduct, including things like racial harassment, could be adjudicated under a clear and convincing standard, but only sexual harassment had to be adjudicated under a preponderance standard. So, in the NPRM, when the Department of Education said, look, you can have preponderance or you can have clear and convincing, but it has to be the same across all types of, suspension and expulsion level misconduct. To me, that was the right formulation. So I prefer that formulation to the one that was in the final rule. But I do not believe in any way that clear and convincing evidence standard violates Title IX.
Well, Sam, OCR had to back off of that standard because of the very clear implication of it, which is if you said that these were the rules that had to apply uniformly to all suspension or expulsion level offenses, then all procedural protections, not just the standard of proof, would have to be uniform across those processes. And they weren't willing to say so because, crazy though it sounds, there is no constitutional principle of consistency.
I'm going to interject here momentarily. As the audience probably is well aware, we could be fascinated with the back and forth between both of you. This is much better than the TV I've been watching the last 3 months during the COVID pandemic. We do have a number of questions that have come in, and given the audience is joining us tonight, I'd like to address some of them. Before I do that, I will preface or throw out some thoughts for you guys to consider, given my background as a military special victim prosecutor and my curiosity as to how these issues ultimately will play out in the Title IX disciplinary atmosphere. One, Brett, you brought up biases, and I think Samantha touched on that as well. One of the issues we had as prosecutors and defense attorneys in criminal trials, courts martial, was potential biases of our jury panel. And voir dire, obviously, in the criminal context, allowed us to assess that out. And the Army, like universities, has taken a strong stance in trying to eradicate sexual assault through the SHARP program and the training to include, unfortunately, at times that one alcoholic intake meant you couldn't consent. And so now you had tainted jury pools and tainted decisions. So I guess question one would be, how do you both think you can address those biases? And then second, both of you have talked extensively on consent, but we haven't got into the consent involving alcohol intake. And when, again, a big issue in the Army was, when is one too drunk to consent? And again, in a criminal context, both prosecutors and defense attorneys would rely on expert witnesses, forensic toxicologists, to come in and backward extrapolate the BAC of the potential victim or the accused And obviously, expert witnesses are expensive endeavors and very time-consuming, even for trained prosecutors and defense attorneys. So again, how will those issues play out, the potential biases, whether pro-alleged victim or anti-alleged victim, depending on the standard, and also on the definition of consent that you guys have already addressed. And then we'll turn to the Q&A after that.
Well, I'll just say quickly that certainly on the issue of bias, I think that the transparency requirement in training materials is important because, over the years, particularly in things that have come out in litigation discovery, and through Freedom of Information Act requests, we have seen training materials that do really rely sort of on stereotypes and that are prejudicial in a way that, they would never be allowed as jury instructions. I mean, you couldn't tell a jury that, 99% of accused murderers are guilty because they're only supposed to be looking at the case of the person in front of them. But, when you're having panels trained with, only 2% of reports are false, and that whether or not that's true, it's prejudicial. And so I think, I really like this requirement of transparency and training because I think that will go a long way towards, eliminating bias. Is it a guarantee? No, but is it a powerful step in the right direction? I think yes. And I don't know what you have to say about that too, Brett.
I would agree with you on that. When the first regs clarity came out, I had a reflexive reaction that was not anything to do with the obligation to publish the materials, but putting my my livelihood out there in the public domain. I make my living from being a good trainer, and I take great pride in our training materials. In fact, our training materials have been litigated quite a number of times in those 650 cases, and nobody's ever been able to point to anything in them that created a bias. And I really do count that as a balanced recognition of what we've tried to do. And then I realized, what? People are going to use this for training. They're not going to use this for training. We might as well just go open source because I am proud of the materials. And I don't have any problem with somebody taking a look at them under a microscope. And so we're providing them to all of our trainees now. We're giving them a way to put them up in public on their websites. I don't want anybody stealing them for commercial purposes. But, if anybody wants to inspect them, I think that kind of is important, but I also think to an extent it belies my experience, right? Because my experience isn't that training is very effective at unbiasing someone, right? Is they come into the room with the biases already. And the training doesn't bias them. I think that's simplistic. I think the training doesn't often unbias them either. But one of the things that we're trying to do is to help schools to better assess for bias. Because if you're sitting on a panel, the first time the school probably realizes if you're a panelist that you're biased is in the middle of the hearing. And that's too late. And so we certify hearing officers. And through our hearing officer certification, we take them through some critical competencies. And then at the end, there's a 10-question test. And it's a substantive test about applying the policy, but it's actually designed to draw out biases. And so what we said to all of the schools is, at the end of the training, administer this to anybody who you would put on a panel before you put them on a panel. And if they are showing their biases from being tested on a real-life case study, don't put them on the panel. So I think we're actually, and we started doing this well before the regs came out, we're very proactively trying to help schools identify what it means to be biased, because bias can be very hidden sometimes. And it might have to do with someone's biography. It might have to do with their politics. It might have to do with the way they have a lens or a filter about sexual behaviors. So this is designed to pull that out and help people try to identify it, because what we're really looking for on these panels is that neutrality, right? The idea that somebody can come to this with an impartiality and be biased by only the evidence and nothing else.
Yeah, and I think, just the requirement of the prohibition on single investigator and the requirement of a panel is also a step in the right direction, because I think, certainly in one of the cases I had, we had a panel, and I had a feeling just by the questions the person was asking, and also having looked into their background a bit, that one of the hearing panelists was biased. She just seemed to be sort of predisposed against my client from the beginning, asking much tougher questions of my client than of the other party. But the other two panelists seemed to be very fair-minded. Now, I have no idea what the other, the client was found not responsible. I have no idea what the ultimate vote was, but I remember during that proceeding feeling very grateful that there were three people there, because one of them asked no tough questions of the other party and only tough questions of my client. The others have tough questions of both parties. So having that backstop again, one of the problems that courts have cited with the single investigator model is that, even somebody who's well-intentioned can have biases and prejudices. So, that just the panel alone is I think, also a backstop.
Yeah, I wouldn't quibble too much with that. I would simply say if we're going to have live hearings, and it looks like based on a number of courts and OCR that we do, then I'd rather see it be a 3-member panel than any other formulation. But I do think it's critical to realize that the OCR doesn't endorse that. OCR has essentially said that while we can't use single investigators, single hearing officers just fine. So, as much as a single investigator can be biased, so can a single hearing officer. They haven't solved that problem with the new regs. The smallest schools, the most resource-strapped schools, they can't afford a panel.
Right.
Thank you both. Turn into some Q&A.
Sex and alcohol question. That's a whole different
that has been debated in the military for a long time, so we'll save that for the next time.
90 minutes, we'll come back for that.
Turn into some Q&As. The first one, I think a couple participants have asked if either of you have any input on the K through 12 setting of these new regs. So a lot of this discussion, obviously, in the collegiate university setting. I think just an overview of your thoughts, how these new regs pertain to K through 12. Thanks.
Yeah, I'll just speak to it very briefly. We have a lot of K-12 members, and they're petrified and paralyzed. And I think if it's going to be a heavy lift, if not an impossible lift for colleges and universities to comply with all their resources, it's 100 times more impossible for your typical K-12 environment. We in higher ed have the advantage of since 2011, at least building on the Dear Colleague letter in the sense of establishing bureaucracy, infrastructure, process. K-12 has always handled these things very, very informally, and I think this is going to come as an absolute shock to them. And I don't know how exactly they'll respond to this, but I think OCR tried to give them a little bit of relief by saying, while we're going to apply this live hearing requirement in the post-secondary context, we're just going to have an informal exchange of Q&A between the parties and the decision maker, and that will be a substitute for the live hearing in the K-12 environment. So I thought it was an interesting acknowledgement by OCR that due process doesn't really have to be in place with a live hearing and cross-examination to reach a fair result. It just depends on how old the participants are.
I would not.
That's back to you, Sam.
I would not agree with that characterization of it. I mean, I think that recognizing that different procedures may be necessary when you have children, is not an acknowledgement that a process, that the optimally fair process is one that involves live hearing. But I think that probably most people would agree that, the prospect of having a 6-year-old cross-examined might outweigh, some of the concerns.
But OCR is perfectly fine with a 6-year-old being cross-examined when they're attending a camp on a college campus.
I do not think, I think that's a red herring. I think that is an absolute red herring. First of all, what did you say?
In the regs.
No, I realize that it is technically in the regs, but I do not believe that that was the intent. And I think that's a bit of a red herring. And you can come back, we can have some kind of bet on whether we will actually see a toddler in a daycare being on a campus daycare being cross-examined. My money is on no, and I'll leave it at that.
You're probably right about that.
I'm going to go through these questions hopefully in order as I see them. Next question is, this may go back to lowercase due process or uppercase due process. Do either of the debaters have thoughts on the Education Department's requirement that campus adjudicators' hearing panels need more training to issue disciplinary sanctions than a jury needs to convict and limit a person's freedoms?
I'd like to start on that. I reject the premise out of hand. The voir dire process in a criminal prosecution is designed very much to get a sense of where the jury is and their understandings. It's not a training, but it is a way of assessing, much in the same way we do in trainings. And while we don't call it this in a criminal process, that's what jury instructions are. Jury instructions, which can be read for days, are training for the jury on how to understand the law and how to apply it. So to make the argument that we don't train juries is as simplistic as saying we don't train college administrators. Everybody gets trained to do the job. It's just a matter of how.
Yeah, I don't think I have anything to add to that.
Next question that I see here is directed to Samantha. It says, Samantha, why is this level of, quote, excessive, unquote, due process required only for sex discrimination cases?
Well, first of all, I would not object to it being required. I mean, the Department of Education can only prescribe due process protections and other guidance for the areas which it regulates, right? I mean, and the government regulates anti-discrimination laws on campus. It doesn't have a say over other campus conduct codes.
But it require these standards for Title VI, which it does regulate.
I would be happy if it required these standards for Title VI as well. You know, and the fact that
due process you didn't like.
I'm going to go with the Rome wasn't built in a day answer. You know, I would support, and FIRE, you know, has always been very clear across the board that this is not about sexual misconduct. This is about, you know, what the type of procedure we believe students are entitled to before they're suspended or expelled from school. And I would support these procedures in any type of proceeding that involves suspension or expulsion. You know, prior to these regs, what we see, and FIRE has put out a report on this for several years now, is that typically schools offer more robust due process protections in other campus conduct adjudications than they do in sexual misconduct adjudications. You know, you'd have schools where you get a hearing on other types of harassment or misconduct, but no hearing for sexual misconduct and things like that. So I think that, you know, restoring that balance was necessary, but I would absolutely support it in the Title VI context as well. And obviously outside of, you know, the federal anti-discrimination laws that the Department of Education enforces on campus, I think schools should provide the procedural protections, but there's no, you know, the government has no say in whether or not they do, except courts of law in due process cases at public universities.
Next question here. If panels are, quote, trained, unquote, to believe that women virtually never lie about what transpired between them and a man, then the preponderance of evidence standard has been met right there when it's, quote, he said, she said, unquote. How is that, quote, training, unquote, conceivably consistent with due process and fundamental fairness?
I would think that would be an absolutely egregious thing to train on. I'd never train on it. I would testify in court as an expert witness against any school who ever used that in training, happily.
But I do think, I mean, I think that, you know, listen, that would at least be a huge smoking gun if we found a training material that actually said, you know, women never lie. But I do think there has been a problem with, you know, panels being trained with materials that do rely on sex stereotypes. It's something that several courts have expressed concern with, and it's something that I think that this new requirement of transparency in training materials is going to remediate to a large degree.
I testified against a school that had in its training materials a statement that said the mere assertion of trauma by the victim is proof that a sexual assault occurred. There's crap like that out there, right? But part of what we tell our members is vet it carefully, right? Because there's stuff back from 1984 that's still stuck in a training folder, and you never actually used it to train the panel. You just gave it to them in background materials. But we've got to carefully vet these things now, especially since they will be public.
Great, thank you. Next question. I'm interested in your thoughts about the limitations of Title IX to, quote, on-campus, unquote, conduct. The real issue for us as educators is to what extent can and should we extend protections akin to Title IX to off-campus assault. I assume those who represent the accused will object strongly to that, but the idea that location controls will feel inherently unfair to victims where students are involved. Well,
I will say that as someone who represents the accused, I don't myself have a strong position on location controls. I mean, from a you know, practical standpoint, I can certainly understand why an assault that happened off campus when students have class together or something like that, you know, could have effects that spill over onto campus. The thing is, though, that the language of Title IX itself, you know, says that confines the scope of prohibited conduct to situations where the school has control both over the harasser and over the environment in which the harassment occurs. And that's something that the court talked about in the Davis decision, but they talked about it not only in the context of a private action for damages, but also just in terms of the statute's plain language. So, the plain language of Title IX just does not extend beyond that. Is that something that I would object to a court changing? Not necessarily, because I personally, as I said, can agree that there could be situations where off-campus conduct, truly could affect a student's ability to function in an education program or activity. But, that is the Supreme Court's interpretation of the statute, and I think that is what OCR's followed here.
Yeah, I was actually going to point out that one of my critiques of the regs is that if a complainant has the good fortune to be sexually assaulted off campus, he, she, or they would likely be able to have a resolution without a live hearing or cross-examination, which is probably a lot more palatable to them than if they'd been sexually assaulted on campus. OCR has set up this dual system that is going to be very complex for institutions to navigate and is going to be very confusing for students and employees when they see a whole set of rights attached to one process and not another, not depending on how they've been victimized, but simply based on where they happen to have been sexually assaulted.
Well, and listen, I agree with you, as I said before, that schools should be providing these procedural protections in all of their conduct processes. And it's disappointing that they're probably not going to, and that's something that, as someone who advocates for due process rights across the board, I will continue to advocate for. But the reality is the government's ability to regulate that is limited to the statutes that it enforces on campus.
Yeah, 38 states haven't agreed with you yet on that.
Next question here, pretty broad for both of you. If the Title IX regulations won't fix the issue and our judicial system doesn't fairly address sexual violence, what is the solution to responding to this epidemic of sexual violence? That is a question, and I guess a related question is, do you think that there is an epidemic of sexual violence?
Right, I mean, I will say, listen, I mean, we've seen now how schools responded to an epidemic, right? They closed, and they closed largely before they were required to. Do I think there's a problem? Yes. But do I think that it is the epidemic that it has been made out to be? No. And I would go back to what I was saying before, that I think a lot of the dialogue around campus sexual violence reflects the fact that universities really are trying to enforce through their judicial systems a set of shifting norms around what it means to consent to sex, not, Brett, whether you need to have consent for sex, but around what it means to give consent to sex. So I think that, I don't like the epidemic language. I think that it breeds a panic that has led to poor decision-making in this area, and that we can all agree that even if it's 1 in 100 or 1 in 50 rather than 1 in 4, that it's something that needs to be taken seriously and addressed. But I think that this epidemic language has been really harmful.
Yeah, I'm never going to get into a debate about how much sexual assault is minimally tolerable within a society versus how much isn't. That's a somewhat offensive question, but not that you meant that way. I would interpret it that way. But what I would say is, if you're looking to build a better mousetrap, I do think that part of the reason why we are beset by the Me Too related social upheaval that we have been in our society is because we have accepted that organizations are allowed to self-deal on these issues. A corporation that can be sued for its chief executive using sexual favors to advantage has to decide whether that chief executive has violated its policies. A college that can be sued by any student for the outcome of its decision gets to be the arbiter of whether its policies were violated. So, if the question is, how do we systemically try to remove the incentive to commit sexual harassment and sexual assault because people know they can get away with it because they own the company, or the company is going to protect them, or the school doesn't want its reputation tarnished, you've got to put this outside of the organization for resolution. This is why third-party neutral organizations, in part like ours, are successful, is because a lot of forward-thinking, wisdom-based organizations have said, you know what, we don't accept the fact that we're self-dealing on this, and nobody else should either. The integrity of this process requires that we put it out there within neutral, impartial arbiters who aren't beholden to any organizational aims, goals, bottom line, shareholder value, reputation, etc. And I think we're probably 10 years away from seeing the organizations of our society accept that premise and move to it. The question is, what does that external resource look like? God forbid it's a government agency or even a quasi-government agency. Perish the thought. But it does need to be orchestrated on a systemic level. If it serves colleges and universities, great. If it serves Olympic sports like the Center for Safe Sport, which is a microcosmic model of the idea, if it serves corporations, government agencies, we can't be doing this ourselves. We don't have the talent, we don't have the resources, and we don't have the impartiality to pull it off.
Just a general comment here. I think kudos to both of you from this participant. It is evident from this debate that both of these experts really want a system to work, ! Maybe a follow-on geared to developing a strong best practices model. Maybe Samantha and Brett should continue this discussion. So maybe this will be a revolving debate weekly or something like that. But
FIRE just came out with a model code of conduct for schools that incorporates these protections both into its Title IX and non-Title IX proceedings. So, if we're talking about best practices, that's something we're hoping schools will adopt.
Yeah, somehow you managed to fit into, 15 pages, what it took us about 105 to accomplish. So I wonder which of us went overboard and which of us went underboard.
And I'm going to interject a comment here of my own before returning to some of these other questions before we wrap up. Brad, I chuckled at your introductory comments about the Republicans now siding with protections, I guess, in the face of sexual assault allegations. Hot off the press this morning was a New York Times article entitled, quote, "Trump Overhaul of Campus Sex Assault Rules Wins Surprising Support," unquote. And politics aside, I found this one particular quote in the article humorous. It says, quote, "The new system is vastly better and fairer," unquote, said Professor Janet Hawley, who specializes in gender and sexuality at Harvard Law School. Quote, "The fact that we're getting good things from the Trump administration is confusing, but isn't it better than an unbroken avalanche of bad things, ? Unquote. I guess an endorsement, not an endorsement, but a recommendation for the audience to check out that New York Times article to see some perhaps liberal feminist opinions on these regs. And that was an unfair question because it literally just got published a couple hours ago. So,
I did see the piece, and Janet Hawley has been, a staunch advocate of due process on campus from early on, in part because she's recognized something that I'm sure Brett has seen too, which is that, despite the sort of prevailing narrative of this being sort of a problem of sort of privileged frat boys getting away with everything on campus, that actually, when you look at the students, at least, I can't speak to all of the students accused, but certainly when you look at the lawsuits that have been brought, it does seem like there is a disproportionate effect on students on men of color, on, underprivileged students. And so, the idea that these types of biases, when you have a system that is already biased against the accused, that additional biases wouldn't also work their way in, has been something that has concerned a lot of people, and that's something that Janet Hawley's been sounding the alarm bell on from early on. So it didn't surprise me to see her coming out in favor of these due process protections.
No, but it surprised me to see that she concluded that the system is better, given the fact that it exists on no college campus, hasn't been employed yet, and has not yet taken effect. So my suggestion is that she's perhaps a little premature in congratulating the Trump administration on its monumental achievement, and that perhaps we ought to take a little bit of a wait and see to see how this thing plays out. But I think the law of unintended consequences will inform our debate next year when we sit here and say, oh, we really didn't see that this was the direction these regs would take us. Look what happened. Everybody put everything into informal resolution, just like the regs said they could. And now we're doing exactly the same thing and hosing the respondent. We're just calling it informal resolution now.
I think timing here as we approach the 2-hour mark, I think maybe 3 more questions here, and then we'll give you both an opportunity to make any final remarks you want, and Matthew as well. And with that said, the next question, and they preface this by saying not meant to be snarky. This is really a 2-part curiosity question if there's time for it. Question 1 of theirs is, would either of you want to be a Title IX coordinator? And secondly, what would be your number one concern and or worry on August 14th if you were a Title IX coordinator?
Sam, you want to go first?
I would not want to be a Title IX coordinator. I mean, I think that, like I said, I think that university administrators are in a very difficult position and have been in a very difficult position for the past, what's 1995 to 2020, 25 years now. And that Title IX coordinators have a lot on their plate. I know that a lot of them are trying really hard to do a good job and to do it fairly. And they have a lot to contend with. In terms of August 14th, as I said, I think that, the argument about the short implementation period here is somewhat disingenuous, and that I think schools have known this was coming for a long time and could have and should have been taking steps to reform their procedures accordingly. So, what would my concern be? I mean, obviously it would be, have I come into compliance? But I think if I have not come into compliance, that the school really sort of only has itself to blame for not, seeing the writing on the wall as early as November 2018.
I think that's practically a heartless response, right? Even if colleges and universities began the preparation process well in advance of the final regulations because they have the draft regulations, any observer of the differences between the draft and the final would say that they are so fundamentally different from each other that anything a school had done to prepare would have to be completely redone. And
putting a hearing process? I mean, what differences do you think are so dramatic that a school would have to undo all of the work it had put in?
I think just the distinctions in the way that cross-examination is handled requires a huge difference, right? Colleges have to sit down and figure out, all right, well, who does direct examination? And if we have an advisor who doesn't want to conduct cross in the middle of a hearing, how in the middle of a hearing do we find a substitute advisor who will question on behalf of the respondent and who knows what to do and how to do it? No, the complexities are so full of depth that I think that anything a college would have done to prepare, and I don't accept the premise that colleges did nothing to prepare, but they would not be able to make the adjustments within 90 days. And so I think they've been set up to fail. I think in part OCR wants to see them fail because as an enforcement agency, that's their bread and butter. And I'm dedicated.
I think that's pretty cynical. I don't agree with you. I think they want to see them succeed.
OCR issued a statement from the Open Center yesterday saying it would have absolutely no problem if the hearing decision maker and the investigators conferred offline behind the scenes about what the investigator's opinion of the case was. You feel that's a good piece of advice for OCR to be giving? Or is it setting colleges up?
I'd have to see that. I hadn't seen that.
Oh, I'll make sure you see it. So the answer to the question, would I want to be a Title IX coordinator? At some level, I don't envy them the task ahead. But at another level, I've worked with them for 10 years, and I know a lot of them really, really well. And I know how much gratification they get from moving the wheel forward, that they see themselves as the custodians of an important, balanced task, of a sacred responsibility. They take it seriously. They try their best. They're often working in very resource-strapped environments. And they've made remarkable progress over the last 10 years. Have they gotten it all right? No, but no system of adjudication ever does. And I think that it would be very gratifying work to at least work within an organization where the hierarchy supported the Title IX purpose, provided the right kinds of resources and support for the Title IX coordinator to do the job right. What I'm worried about with these regulations is they only address 5 things. Right? They only address sexual assault, sexual harassment, domestic violence, dating violence, and stalking. They ignore athletics. They ignore pregnancy. They ignore trans student rights. They ignore the whole constellation of all the things that Title IX was intended to protect. So all of the time and attention has to go into building an infrastructure for these 5 types of incidents. And will we pay attention to access in STEM programs? Will we pay attention to access to bathrooms? Will we be attending to all of the things that Title IX requires, or will this suck up all of the oxygen in the room? That's if I'm a Title IX coordinator as of August 14th, that's what I'm worried about, being spread too thinly that I can only address the regs and not do the rest of what my job requires.
Thank you both. This next question is directed to Samantha. Samantha, what do you suggest that institutions should do to protect the campus when the institution has received multiple unrelated reports of forced and aggressive allegations of sexual assault by the same person, and no complainants want to participate in the process due to the complexity of the new hearing process and required in-person cross-examination?
Well, first of all, I don't like the sort of premise that, complainants are not going to want to proceed because of the procedural protections that are in place. Look, I mean, if something has happened and someone has been victimized, they need to come forward. And I realize that people are probably going to disagree with me on that, but I think, in the criminal justice system, if we want crimes to be prosecuted, victims need to come forward. It sucks to be the victim of a crime, and it sucks to have to go through the process. But that doesn't mean that, we have to make it such an easy process that we find people responsible for it without actually, going through the meaningful process necessary to determine if they're actually responsible, which is what has been happening, at least since 2011, is that the Department of Education just made it easier to find people guilty, whether or not they were actually guilty, in an effort to bring more complainants forward. And I think that was wrong, and I think that was unfair. And so I reject the premise, to use Brett's term, that, having these procedural protections in place somehow means that, complainants cannot come forward with claims of assault. That said, a school can take action to protect the safety of the campus without a complainant if it has reports of these things.
That's pie in the sky, but in theory it exists. Let me ask you then this, Sam. Would you commit, let's say 2-3 years from now, that once these regs have been in place long term, if the effect is that formal reporting of sexual violence in college campuses and K-12, holding COVID, neutral, right, has dropped by 90%, would you agree that something has to be revisited in Washington to fix that?
Would I agree that something has to be revisited in Washington to...
Yeah, if I'm right, the reporting drops off a cliff. 90% of what we saw in 2018, 2019 is our 2022 reality. Would you agree that the regs have not done what they intended to do?
Not necessarily, no. I mean, I think that, as you said at the beginning, do I believe that Title IX mandates disciplinary procedures versus mandates schools to take action to restore educational access? No, I don't necessarily believe that prior to the 1997-2001 guidance that the Department of Education required schools to have these judicial processes. So, if the question were a broader question of, is looking at this through the lens of disciplinary processes versus focusing purely on restoring educational access through things like supportive measures, is that a question that should or could be revisited? Sure, I'd be willing to revisit that. But as long as we have these judicial processes, I'm going to insist that they be fair. And I think that these types of protections are needed to make them fair. And I think that, what the Department of Education did in 2011 is sort of exactly what you're saying. Well, we need people to come forward, so we need to create a kinder, gentler process where it's a lot easier to find people responsible and where it's not hard to come forward. And the results of that have been disastrous. So if we want to revisit the whole judicial model from the 90s onward, sure, we can have that conversation. But if we want to revisit the need for due process protections in these proceedings, then no.
Yeah, I just want a balanced result, right? I want a result where we have an environment where those impacted by sex and gender discrimination, regardless of how they identify, male, female, non-binary individuals, that they have a recourse, and that the respondents in the process are treated with the appropriate level of due process, procedural fairness, and impartiality in terms of a decision being rendered. I think, and maybe I'm just looking for a panacea, but I think a balance between those competing goods can be achieved. Do I think the Obama administration achieved it? No. Am I sure the Trump administration is not? Absolutely. And maybe I'm acting prematurely like Janet at Harvard, but I've been doing this long enough that I don't think this is the right answer.
And on that note, as a final question, and when you answer this question, feel free to make any final remarks that you both want to do. And then when you're done answering this question, we'll toss it to Matthew for any final remarks he wants to make. But my final question for both of you is, imagine that it is now June 24th. 2022, 2 years hence from now. Where are we? Are these regulations still in place? And part of your answer might involve who the president is at that time. But again, 2 years from now, how are these allegations being adjudicated on campuses? Thank you both, by the way.
Well, you know, it's interesting. I think that a lot of that will depend on sort of what's happening in the world. I mean, certainly it's going to depend on, you know, who the president is. But I think, I mean, looking at what's been happening on campus over the last few weeks, just to say, I think we're about to have sort of the conversation around campus racial harassment policies and enforcement that we started having around campus sexual harassment policies and enforcement in sort of the years leading up to 2011. So I think, you know, there has been what I would call almost a moral panic around this issue on campus and in society at large for the last stretch of years that I think has led to sort of this, you know, denial of due process, the environment in which due process was being denied. I think it's possible that in a year or two, this is not going to be the issue that's on everyone's radar screen, and that, you know, the focus is going to be on other things. You know, in terms of whether these regulations are going to be in effect, this has been such a roller coaster ride from the beginning that I really don't, you know, other than just sort of shaking the magic 8-ball, you know, and getting the sort of results are hazy answer, I really don't know. But in terms of my closing remarks, you know, I'll just say that, you know, I think we sort of began this discussion, and then the question Brett posed to me is, you know, do schools need to have judicial processes at all to handle Title IX claims? You know, and is that the right way to go? And I said, listen, I don't know, but that ship sailed 25 years ago. And I think that, you know, what we have seen over the last 10 years is that OCR, you know, expect schools to have these kinds of judicial processes, and that when schools sort of have that mandate but don't have the detailed guidelines for how to do it fairly, the wheels have really come off, and there have been sort of too many lives ruined. And, you know, these due process protections in the regulations are necessary to restore fairness to the process. I don't believe that having due process protections in the grievance procedures violates Title IX's mandate of equity. I think that, you know, a lot of what the regulations do in terms of the focus on supportive measures is actually restore the focus to the non-discrimination mandate and to, you know, maintaining equal educational access. But I think that, you know, we have to take things as they are, and looking at the situation as it is and as it has been since the 90s, that these regulations are the only way to restore fairness to this process.
I heard that if Trump is reelected, that one of his campaign promises is to rename Title IX the Full Lawyer Employment Act, because that's what it's going to be if he stays in office.
Did you mean for that acronym to be FLEE, Brett?
Never thought about it.
Maybe you could have come up with an acronym that's called SHARK.
I do have an empire of acronyms. I'm frequently critiqued for that. But I think that the future of Title IX in the Trump administration is endless litigation. And we've already seen it for the last couple of years, and I think it gets much worse. And I think that our students are the casual byproduct of a war between attorneys, and I don't know that serves anybody well. If Biden is elected, he's already committed to reversing the regulations, and while I think that's would be a stopgap, I also think that it's probably not the right solution. I would love to see a statute as beloved and upheld by the Supreme Court over and over again as Title IX, insulated from being a political football. There is no reason why every 4 to 8 years we ought to be fundamentally reshaping the way colleges and schools address the issue of sex and gender discrimination. It takes that long just to get our feet under us to develop programs, and then there's an election and they sweep it all away. Colleges and schools can never achieve excellence at this task when the rules keep shifting. The rules shifted in 2011. They shifted again in 2015 with VAWA Section 304. Now they're shifting again. If Biden's elected, they'll shift again. And so that is the fundamental problem that I think schools are facing, is we never know what set of rules we're going to have to comply with. And by the time we do get a compliant regime set up, they change the rules. So if we can find a way through a bipartisan effort in the next Congress to permanently insulate Title IX from the political process, that's what I'd like to see. I'd like to see a bill that has the best protections for complainants that were the hallmark of the 2011 approach from OCR, and the best part of the protections for respondents that are part of the 2020 approach from OCR. There's a halfway point on all of these things that is not an extreme, that doesn't require the pendulum to swing as wildly as it has been. And that's what I think all of us who are on the same side of believing that Title IX has been a 48-year trajectory just this week of bringing access to education in a beneficial way. I think that's how we ensure its legacy for another 48 years to come.
Thank you both. Personally, I want to thank you both for your time, and I know the Federalist Society as well. Additionally, if Matthew is still on, I will send it to him for some final comments as the president of the chapter of the Federalist Society. Thank you again, both.
A pleasure.
I am indeed still on, and I wish to extend the chapter's thanks to Brett and DeSan for a debate that was as collegial as it was informative. I enjoyed it immensely. David, thank you for moderating, and to the audience, thank you very much for joining us. I hope you enjoyed the event. Good night.